everyone, my name is Allison Grosz. I'm an attorney and a partner with Hemrick O'Malley, PLLC here in New York City. Today I want to talk about acquisition and derivative citizenship because this is something that's been very common in the news recently with the new Trump administration. And I've also been getting a lot of questions about this topic, which is a little bit nuanced in the immigration law. So let's talk a little bit about acquisitions and derivative citizenship. I'm actually going to do this sort of video in multiple parts because there are a lot of details that need to be shared. Today I'm going to talk about just the acquisition of citizenship at birth through your parents, because there are multiple ways that a person can acquire or derive citizenship both at birth, also after birth, and believe it or not, through grandparents, which we're going to be talking about in a different video. So today we're just talking about the acquisition of citizenship of a person at the time of birth from their parents. Now, generally speaking, a person can acquire citizenship at the time of birth in two separate ways. Of course, the first way we all know about, which is birthright citizenship, meaning that you were physically present and born inside of the confines of the United States. If you were born inside of the United States, then the United States recognizes under birthright citizenship that you also are now a citizen, meaning that you have acquired citizenship at the time of birth. The second way, of course, is a little more complicated, and that is the acquisition of citizenship if you were not born in the United States, meaning you were born somewhere abroad. Very generally speaking, there are three different ways that you can acquire citizenship at the time of birth if you were not born inside of the United States. The first way is if both of your parents are U.S. citizens and you are born abroad. If both of your parents are U.S. citizens and you were born outside of the United States, the only requirement in order for you to acquire citizenship is that one of your parents must have spent at least some time, there's no specific time required, residing inside of the United States prior to your birth. The second way to acquire citizenship is if one of your parents was a U.S. citizen at the time of your birth and one of your parents was a U.S. national but not a citizen at the time of your birth. If that's the case, then prior to your birth, the U.S. citizen parent must have resided inside of the United States for at least one continuous year prior to your birth. If your U.S. citizen parent resided for at least 1 year continuously inside of the United States, then you can acquire citizenship at the time of birth. And the third way, which of course is the more complicated way, is if you are a child of one U.S. citizen parent and one non-resident parent, meaning a parent who has no legal status inside of the United States, not citizenship, not legal permanent residency, and nothing else. So if you have one U.S. citizen parent and another parent who is an alien resident, meaning somebody who is not legally in the United States and doesn't live in the United States, is a citizen of a different country, and you were born outside of the United States, well, then, generally speaking, if you were born after a certain time in 1986, the requirement is that your U.S. citizen parent must have resided for at least 5 years total inside of the United States, at least 2 of those 5 years being after the age of 14. So to recap that, if you were born after 1986, specifically if you were born after November 14th, 1986, then the rule is your U.S. citizen parent must have resided physically inside of the United States for 5 total years, and that total amount of time can be cumulative. It doesn't have to be consecutive. Cumulative 5 years, at least 2 of those years being after your parent reached the age of 14. Now, of course, before November 1986, the rule was slightly different. So if you were born between 1952 and November 1986, then of course a different period of time of residence for your U.S. citizen parent applies. Specifically, if you were born between 1952 and November 1986, then the rule is your U.S. citizen parent must have resided for at least 10 continuous years inside of the United States, 5 of which was after the age of 14. Of course, there are different rules and regulations for pre-1952 births. However, we're not going to go into those because the law changed quite a bit since its inception, and therefore we're only talking now about 1952 to 1986 and 1986 until present. Of course, it's always important to take into consideration as well that there are caveats for people whose parents have not resided physically inside of the United States because of either military service membership or other diplomatic U.S. relations. So, with that being said, this is the first part of my multi-part series that's going to be about the acquisition and derivative citizenships. Of course, you can see this is a pretty complex matter, but a lot of people can and do benefit from this area of the law. We here at Hemrick O'Malley, PLLC, help determine whether people have acquired citizenship or whether they are able to derive citizenship at a later time. We're happy to talk to anyone who has questions about acquisition or derivative citizenship. You can contact us online at hemrick.law, or you can contact us by phone at 833-848-7838. We're happy to hear from you, and we're happy to, of course, answer questions about any other immigration matter. Until next time, I look forward to talking to everyone again soon.